going to share the slides and the recording with everyone on the call today. So without further ado, I'd like to introduce our expert speaker for today, and this is Danika. After almost 12 years representing nonprofits and tax-exempt organizations at a firm called Haynes & Boone in Dallas, Danika established Mendrygal Law over 4 years ago now, it looks like. And her firm is devoted exclusively to representing and advising nonprofit and tax-exempt organizations, as well as advising boards, officers, and staff. Danika is rooted in the local nonprofit community as a volunteer and as a speaker. She works with a small women-only team of lawyers and professionals within her firm. She was recognized as one of the top women attorneys in Texas in 2019 and as a super lawyer in 2018 and 2019, both by Texas super lawyers. She currently serves as the chair of the TEGE Exempt Organizations Council, a national council that coordinates educational programs for the EO sector and communicates with the IRS to provide practitioner perspectives. So Danika, thank you so much for agreeing to do our expert series today, and we are so excited to have you on the line. Welcome, Danika.
Fantastic. Thank you, Andy. I'm happy to join you all today. I thought it might be helpful for just to take a moment before I jump in and give just a tiny bit more background about the type of work we do, not to sound like an advertisement, but rather to give all of the attendees perspective on really just kind of where we're coming from in giving these comments, where I'm coming from in giving these comments. So as Andy said, like JMT, our firm is devoted exclusively to working with nonprofits and tax exempts. Our clients that we work with really run the gamut with respect to industry and size and type of federal tax classification, whether it be C3, C4, C6, public charity, private foundation, whatnot. So what this means is we do a lot of advising on federal and state tax issues, but we also provide a lot of guidance on state nonprofit law, governance, and best practices. And really, we get to do that from kind of through the life of an organization, from everything from formation through operation through potentially dissolution. Also, because we're a small firm and we have some flexibility, we get to see the application of all those issues from everything from a little bitty startup to a massive private foundation to a kind of mid-range operational organization. So we really just get to see that full gamut, full perspective. The other thing that I want to start off by sharing before we jump in is a bit of a disclaimer, because I know we have a national audience today. I am, of course, based in Texas, and we are, of course, talking about fiduciary duties, which is a concept that is based in state law. Some of those duties may be codified by your respective state statutes. Others may exist by creation of common law from the courts. I'll really focus today more on Texas law, but the good news is that these concepts of fiduciary duties and how they're defined and how they apply, and most importantly, how to protect yourself and your organization in considering them, they generally carry across state lines. But just to be aware, there is some variance in maybe interpretation, application. Some states may have things that they do just a bit differently. New York, for example, in the last few years, New York has adopted a series of additional governance-related requirements that apply to nonprofits operating in their state, to directors, to officers, and they really apply in a new way than they typically have. They take concepts that have typically been framed as kind of best practices and now make them legally mandated. So just one example of a state in which you want to make sure you do some extra research and don't just take what I say today as given. So before we jump in then to fiduciary duties and kind of digging through that, I think it's always helpful to just remind everyone that we need to kind of set the stage first. We need to understand what structure you are working within, and not just your organization, but affiliates within your sort of organizational umbrella, if you will. So an affiliated endowment or foundation, or maybe a title holding company, a title holding corporation that's related to your primary operational entity. So what structures are we talking about? I am consistently surprised and really have been over the course of my career at the sophisticated folks who come into my office, and I run into directors, officers, staff that really don't know what their legal entity structure is or their tax status. And while on one hand, yes, that's something for the advisors to worry about and your CPA and whatnot, on the other hand, it really does or can impact the duties that apply to your directors and officers and your compliance requirements. So take just a minute here and run through some of this basic stuff, and then we'll dig a little bit deeper. So first and foremost, just so that we're speaking the same language, I think it's helpful to just draw a distinction between the phrase nonprofit, and if you could see me, I would be air quoting, the phrase nonprofit and what it really means. And by my take, it doesn't mean a whole lot. So just be aware of that. Nonprofit status refers primarily to your state entity form. A lot of folks who are on the line are probably operating under a nonprofit corporation format. That's pretty common. That's really all it means. There are some essential characteristics that carry through, for the most part, from state to state that sort of define and quantify what a nonprofit is. Things like the fact that the assets don't really belong to any shareholder or private individual, but in some regards are treated as kind of owned by for the benefit of the public. The concept that in lieu of shareholders being around and available to enforce rights on behalf of the organization, there's usually a state regulatory body, whether it be the Office of the Attorney General or some other regulatory body that stands in the stead of a shareholder, since there are none. The concept that there typically are no dividends or things that look like dividends that are permitted to be made from a nonprofit. And then lastly, the idea that there are restrictions on dissolution. If a nonprofit goes away, restrictions on how those assets be used. So that's really all we mean when we're talking about nonprofit. It doesn't really have any indication as to what type of state entity nonprofit form you have. It also has no indication as to what your federal tax status is. So a couple more moments on that then. When we're talking about state status, I would venture to guess that most everyone on the line today, your state status is out of a nonprofit corporation. We're talking about directors, fiduciary duties. That seems like that would be a foregone conclusion. Those, of course, are going to be governed generally by state code, state statute, like in Texas, the Texas Business Organizations Code, or TBOC for short. There may be also additional codes that apply to nonprofit corporations in your respective state that start to touch on things like fiduciary duties. Okay. So I was just talking about charitable trusts, and really the takeaway there is just that understanding that the fiduciary duties that apply to a trustee are different, and that the law in which those duties are based is going to vary if you have a charitable trust rather than a nonprofit corporation. There are, of course, other formats that a nonprofit can be formed in, but none of those really apply to today, so I'm not going to spend any time digging down on those. The other question that we then have to answer that is less applicable to the fiduciary duty question, but very much intertwines with those same related issues is, what is your federal tax exempt status? Are you exempt under 501c? Okay, that should be an easy question and an easy answer. If so, under what section are you exempt? Are you a 501c3, 4, 6, something else? If you're under 501c3, are you a private foundation? Are you a public charity? Are you an operating foundation? Are you a supporting organization or a subordinate within a group exemption? All of those pieces kind of fit together to make the big puzzle that will help you understand not just what compliance your organization is responsible for, but also what duties and responsibilities your directors and officers have, and how all of that intertwines between the state level, state application, and the federal regulatory application. Okay, so with that behind us, and hopefully all those audio issues behind us, we're going to start talking a bit more about this concept of a fiduciary. So as I talk and interact with folks from other careers, with other backgrounds, financial backgrounds, in-house at nonprofits, CPAs, accountants, whatnot, I'm often reminded that these terms that lawyers throw around, like fiduciary and prudent and good faith and whatnot, even the ones that don't sound fancy or complicated to us, may not be as intuitive to others. So I thought I'd just provide a little bit of background. I am not going to read this, but it just gives you kind of the basis for this concept of a fiduciary. And the concept essentially is that you are acting in some type of role that starts to look like a trustee. You're holding property for the benefit of someone else. As I was looking through and trying to kind of put together the presentation, I came across a couple different quotes from a variety of different courts that just talked about this concept of fiduciary duties and whatnot. And I thought these quotes were interesting. I thought the ones that I've included here just provided a little bit more flavor to kind of the background of it all. And particularly on this next slide, this one down at the bottom from the New Jersey Supreme Court, quite honestly, it just cracked me up. This concept that a director is not an ornament and can't protect himself or herself from behind a paper shield bearing the motto "Dummy Director." I kind of laughed out loud when I saw that one, so I wanted to make sure I included that. But I think this is all very accurate, and interestingly, in my experience from dealing with nonprofits and dealing with directors and officers, there seems to be this general presumption that when you're working within a nonprofit, particularly if you're working on a volunteer basis, like so many of our directors and many of our officers are, this concept that, well, gosh, we're out there doing good, we're doing great things, we're just a nonprofit, or maybe we're just a little nonprofit, or we're just a little PTA or a little booster club or a little museum. You know, how is this isn't something, we're not going to get in trouble for this, we're just doing the best we can. And while I think there might be some bits of validity to that, it's just not that simple. And particularly for those of us who do hold these fiduciary duties, you've got to do a little bit, you got to do a little bit more. And I think as this translates to staff and leadership and management in-house at exempt organizations, at nonprofits, I think you all carry just a bit of a burden along with you to help educate your directors and officers and make sure that they understand that there's give and take. You know, yes, you're so grateful for the time that they're contributing and the efforts that they're contributing, but they do need to understand that there are responsibilities and obligations that come with this. And quite honestly, some element of personal risk if they decide to just completely disregard those obligations and those duties. That risk piece is what I tend to focus on when I do board trainings for groups that I'm involved in. Just that reminder of, you know, hey guys, you know, it's you on the line as well. This is not just a question of, you know, have you made it to how many meetings, but rather, you know, have you done enough to satisfy your duties? So here on this slide, I've laid out the 3 duties that I think we've all probably heard about: care, loyalty, and obedience. And then a 4th that, you know, depending on what state you're in, depending on how your state defines it, it kind of intertwines with these others. So we'll dig back through all of these, but this is just the summary slide. So first up, well, okay, so before I dig down, I'm going to admit to y'all that speaking on fiduciary duties is probably one of my least favorite topics to speak on. You will hear me say this throughout, but in my mind, the concepts they're just not that deep. They're not that thought-provoking. In most instances, it's not rocket science. Ultimately, pretty much all of these come down to acting reasonably, acting fairly, doing something that makes sense. And so it becomes a little bit difficult to me when I try to flesh it out and tell people how it is that they should be acting reasonably or how they should be acting fairly. I will. I've got some good examples for you today, but forgive me if I make that comment of, you know, gosh, guys, it's just not rocket science. That will undoubtedly be said again today. So first up is the duty of care. And this is essentially the duty to exercise reasonable care as you make decisions for, take actions on behalf of the organization. And generally speaking, the concept of reasonable care is defined as something that an ordinarily prudent person would do. And again, you know, I'm tempted to make that rocket science comment here. This is not rocket science. It's a question of, are you informed? Are you participating? Are you showing up? Have your directors attended? Have they attended enough to even know what's going on? Have they read the materials? Have they paid attention? Basic stuff. And yet I would venture to guess that a lot of the stuff that is online today probably sees, is thinking right now of the folks within your organization that maybe don't show up, don't pay attention, haven't been to the last 3 board meetings. I think, as I mentioned before, there's a real board education opportunity here, an opportunity for staff, leadership, management to take a role in educating your board members as to what their responsibilities are, what the expectations are, and what the risk is on them if they don't follow through. In my experience, every once in a while, you might lose someone who's serving in a volunteer capacity because you have scared them off, but that's pretty rare. The ones that you usually end up scaring off when you educate them about the risks and responsibilities are the ones you probably didn't want to anyways, and the ones who probably weren't contributing anyways. So real board education opportunity. I think part of that education is to share with them the role of the board, and how that is defined, of course, is going to vary widely depending on your organization and how you run things and how management and leadership and staff interacts with your board and interacts with your officers. But educating on that piece as well. I think key to this issue is the size of your board, the composition of your board. Have you created a board that is really going to be capable of exercising their fiduciary duties? Is it a small, tight group that can pay attention, or do you really have something that kind of looks more like a fundraising board? Maybe it should actually be called an advisory board and not your sort of operational board of directors. Are they going to be able to exercise that ongoing active oversight with respect to the organization? And again, of course, that doesn't mean getting down into the nitty-gritty day-to-day operations. That's not what I mean by oversight. If you have, if we're talking about a small bitty startup that has a group of 3 board members and they're doing everything, yeah, that may mean day-to-day. But for most of the organizations that are dialed in today and listening, you are at least mid-sized, if not significantly larger. And, the role of your board within your organization is going to vary widely. But ultimately, where the buck stops is at the director level, and they are ultimately responsible for oversight of that organization. I talked about engagement. I talked about attendance at board meetings. Also relevant there is the frequency of your board meetings. Has your organization set up a scenario that allows your board members to be engaged? Are you having 1 annual meeting and that's it? Are you sharing information in a manner that allows them to get up to speed and be informed and learn about what's happening such that they can exercise oversight? Or how are you structuring that? And then, okay, covered lack of oversight already. There's kind of a central case when you're talking about duty of care. There was a case out of DC in the mid-70s. There was a nonprofit that had been set up for 20 plus years. And for most of that 20 years, the management of the organization had been dominated pretty much entirely exclusively by 2 officers. They were the ones, the founders, they were the ones who kind of did everything they recommended, the board adopted. The board rarely met. The finance committee hadn't met in something like 11 years. And that has really become the presidential, don't do this case for duty of care. But that's pretty far on the end of the spectrum. I wouldn't advise my clients to just make sure they met that standard. I think you've got to go a whole lot further than that. And I think then that brings in this question of, well, how do you demonstrate that your board has exercised this duty of care? And ultimately, I think that the best way, hands down, is minutes. And it's so interesting because having been in this practice for almost 16 years, it is such a basic concept. We all know it's required. We all know it's important. Most of us understand why it's important, and yet it is so ignored so commonly, even in the professional networking organizations that are made up of a bunch of lawyers who advise nonprofits. even we're a little more lax about our nonprofit minutes than perhaps we should be. So incredibly important as a mechanism to demonstrate the exercise of this duty of care, to demonstrate that your organization met its requirements, and to demonstrate that your directors and your officers met requirements that apply to them. So it's really protective of kind of everyone at all levels. Of course, we could talk all day long, and I could do an entire presentation on minutes and, what the content is and how far do you go and how deep do you dig. But for this perspective, really the key is not what are the detailed, components of your minutes, but have you kept them, and do they reflect all of these things we've talked about: the oversight, the engagement, the questions, the participation, the attendance. Do they show who came to your meetings and who missed? All of those pieces, that is your way to demonstrate. And of course, making sure that you have a process in place to maintain those minutes long term, so that if ever asked, you can demonstrate that, is also incredibly important. I'll take a minute here to kind of dig down on minutes a bit more. I think we all understand that, of course, the board of directors should be keeping minutes, and probably most of our organizations are doing that and probably doing a pretty decent job. I think there is a significant lapse, though, when you drill down beyond the board. I would argue, and I advise all of my clients, that for any of their significant committees, however you define that and however that works within your organization, typically it's going to be your financial committees, maybe investment committee, those types of groups, they should be keeping minutes as well. I will admit that can get a little bit sticky because those committees address sensitive issues from time to time. So sometimes it raises some sticky issues about document management and who has access, and were you talking about compensation of a staff member? How do you handle that? But regardless, you need to come up with a process that will work for your organization, that will allow those big important committees that are getting to kind of the guts of your organization's operation and oversight, that needs to be documented as well. One really strong example here would be in the compensation context. If you're dealing with a public charity or a 501c4 to which Section 4958 intermediate sanctions excess benefits applies, any compensation decision that your organization makes with respect to essentially an insider, that if you want to rely on the safe harbor under that section, you've got to document all of that, and you've got to document it in advance. You've got to document your accusals. You've got to document that data collection process to pull comparables and all of that. So that's just one probably really strong example that we spend a lot of time advising clients on. And one thing I've mentioned this a few times as I've gone through and talked about the duty of care, but we're focused on fiduciary duties as they apply to directors. But I'll take a moment to just draw out for your attention that some of those fiduciary duties, most of them apply to some of your officers as well. How those apply, again, is going to vary on a state-to-state basis. It's going to vary on how you define officers within your organization, what responsibilities you've given to them, but it's not a concept that is strictly limited to directors. I just included this for kind of some additional background information. I'm not going to spend a lot of time, but this is from Board Source, kind of one of their main publications that digs down into the responsibilities of a nonprofit board. These are some examples that they give. These are not so much legal issues, more kind of practical, operational, best practice types of stuff, but I included it in here in case it is helpful to y'all. So reliance on things that other professionals or officers and employees have shared is another important concept, because when we're talking about the duty of care, of course, directors and officers may not be doing everything on a day-to-day basis. They're not going to have that direct information. They may not have the expertise necessary to pull together financials or prepare a tax filing. So in exercising these fiduciary duties, directors and officers both, generally speaking, are entitled to rely on information, opinions, reports that are prepared or presented by others. And here's kind of the list, officers and employees. So if you're controller is presenting financials, or your CFO, your lawyer, your accountant, investment advisor, you're entitled to rely on them, but only to the extent you have acted in good faith and with ordinary care. So you can't just blindly rely on some outlandish, ridiculous statement. You can't blindly rely to the extent there's no buttressing or backup information. You have to do it in good faith and with ordinary care. And I will say this rule, this is based off of the Texas Code, or this, I think is, yeah, based off the Texas Code. But it has corollaries in the Model Nonprofit Corporation Act, which is what, you know, most of the states have used to adopt this. So this concept is fairly common and runs throughout. The other sort of protective concept in this area of duty of care is that of the business judgment rule. I would imagine most of you have heard of this before. It's this concept that, you know, hindsight may be 20/20, but hindsight is not the standard that should apply to a corporate director, a nonprofit director, in assessing whether or not they carried out their duty of care. The concept that a court will generally not come in and substitute that court's judgment for something that, for a decision that the board or the directors made, so long as there's nothing else going on, so long as there wasn't fraud or actions beyond the scope of authority, negligence, gross negligence, or maybe a complete failure to act. So very protective if, again, you're acting reasonably and fairly. Getting back to that not rocket science concept. So moving on now to, excuse me, to the duty of loyalty. This one I actually think is the most fun to talk about, probably with duty of care second best. This is just about the only fiduciary duty that I spend much time advising clients on, because this is where conflicts of interest arise. And that's something that we advise on pretty regularly. Of course, the general concept here is that a director and an officer are generally required to act in the best interests of the organization. And in order to do that, that individual cannot put their personal interest or some other interest of some related party to them, a family member, an employee, or whatever, a friend, above or beyond the interests of the organization. The nonprofit's interests have to come first and foremost if you are wearing your director or your officer hat when you're making that decision. So that doesn't mean that after you go home when you're making a personal decision, right? Not then. But if you're in your board meeting, you're acting on behalf of, making a decision on behalf of the organization, that nonprofit's interests come first, end of story. This also applies in the concept of confidentiality, in the sense that a director or an officer cannot take information that they have learned from that organization that is not public and use it in some manner or publicize it in some manner, unless, of course, they've been authorized to do so. It also applies to this concept of corporate opportunity. If some, opportunity, some possibility, some deal arises at a board meeting, that director can't then turn around and say, "Ooh, no, you know what? I'm gonna do that. I'm gonna take that. Forget the nonprofit and what would be best for them." In the context of, I'm sorry, let me back up for a second. So I talked about not putting your personal interests ahead of the organization interests, but I think one of the questions I get pretty often is, well, what counts? What counts for purposes of a conflict? What is a conflict and when does it matter? And I think in that context, to some extent, your respective state law may define it. Your respective state law may also give you a little bit of an out, not with respect to exercising your duty, but you may have a provision in your state, like we do in Texas, that says something to the effect of, well, even if you had a conflict, as long as what you ended up doing was fair, we're still going to let that transaction stand. But even if you have a provision like that in your state law, it does not impact whether or not that director, whether or not that officer that maybe failed to disclose the conflict, exercise their duty of loyalty. Now, hopefully all of you have conflict of interest policies in place. Hopefully you follow them. Hopefully that policy is a good policy and it lays out all of the steps in assessing whether or not you have a potential conflict, how you might define those potential conflicts. Hopefully it requires that those conflicts be disclosed, and it addresses the procedures as to what happens from there on out. Usually it looks something like disclosure, assessment of whether or not a conflict actually exists, and then possibly recusal, where that individual with the conflict steps out and doesn't participate in that discussion, doesn't participate in that vote. The one little nuance there that I'll share is, let's say we're in a board meeting and we're discussing hiring my law firm. I'm on the board. I'm a voting member of your board, and we're discussing hiring my law firm for your organization. I raise my hand and say, hey guys, remember I'm here. I vote on the board, and I run the law firm, so heads up. I say, okay, yeah, you're right, you shouldn't talk about that. And I say, well, hey, before I step out, can I give you all just a little bit of background about my firm so you understand whether or not this is a good hire, whether or not, just factual information about my firm. That's fine. I can give them a little bit of background, I can give them my spiel, and then I step out, I recuse myself. The remainder of the board continues to address that situation. They talk about it, they discuss, they vote, and then I'm brought back in. And of course, our minutes would say all of that. They would say that I disclosed the conflict, that I stepped out when I came back in. They would walk through that entire process. That's generally how you want it to work. The other piece that I will share here, and these are not really legal concepts, but in my mind, I find this is an easy way to categorize. As I said, I talk a lot with clients about what a conflict is, when there is one, and to what extent it matters. And so in my mind, I tend to categorize conflicts into 3 buckets. And I've got these here. But again, don't put too much meaning to this. I just think it's a helpful way to think about it. These are just not legal concepts per se. So first, you have a potential conflict, something that you're just not quite sure. Maybe it is, maybe it isn't. That's the type of thing that, again, you want to raise for discussion and consideration at that governing body level, whether that be within a board or within a committee. You have an actual conflict, either something that is so obvious like the example I just gave, or something that the board has then said, okay, here's this potential conflict. Yeah, we do think that rises to the level of an actual conflict of interest, and we need to address it accordingly. And then this third category, interestingly, even though I'm talking a lot about the legal concept of conflict of interest, this appearance of a conflict, this is the one where the rubber hits the road for most of my clients. Ultimately, I would say 75% at least of the conversations that I have about potential conflicts of interest come down to this question of, does it really matter? Does the organization care if it's legally accomplishable despite the conflict? Do they care that they can address the conflict issue? Because there's still an appearance of a conflict. It still looks bad, even if I didn't vote on whether or not you were going to hire my husband or my kid. It still looks bad. And when you splash it up on the front page of the Dallas Morning News, it's going to look just as bad, particularly if there are some other bad facts to throw in there. So, just throwing that out for consideration. The other concept that I think is worthwhile considering here is that of what we call an external loyalty. I think this is something that's really glazed over. I think people are aware of the definition and possibility of a financial conflict of interest, right? Or an employment situation. Those are pretty obvious. But this concept of there being some sort of external loyalty that might disable or not allow a director to carry out his or her duty of loyalty, I think is impactful. So much so that we've actually pulled this into our form of conflict of interest policy. We have it defined as existing if you have a member of the board or an officer that holds a similar role with another organization, or is personally active in some other organization, maybe another nonprofit's affairs, or even as a significant donor to another organization. I think we've all seen this similar scenario of, there are people in the community that are incredibly active and incredibly gracious and donative with their time and money. And they may not just support one organization, but as the nonprofit industry evolves and becomes more active, I am seeing much more interaction and much more, aligning, coordination, whatnot, within our local nonprofit community. And so it's not unusual to have an issue arise at the board level where two organizations' interests, two different nonprofits, or maybe a for-profit and nonprofit, whatever it may be, those interests don't align. And just because there's not a direct financial conflict, I would argue that is just as important as something that's more direct. I'll also throw out here one of the things that I think is incredibly interesting, and maybe this is a little esoteric as to why it's interesting, but it's very impactful to my clients, that this is one area where there is a complete intersection of federal law and some of the kind of prohibited transaction excise taxes that apply to tax-exempt organizations under 501c. This is an area where those excise taxes intersect with the state law concepts of fiduciary duty. So often when an organization comes to me and says, hey, we think we have a conflict, how do we deal with this? They are only thinking of that conflict and how to, protect the organization, how to protect the individual with the conflict, make sure that contract or decision isn't voidable, that sort of thing. So often they completely forget to address the federal tax issues. So for example, if you are a private foundation, if that is under 501c3, if that is your federal tax status, self-dealing very likely does apply. Now there may be an exception, but those self-dealing rules need to be considered as part of this process and not viewed in a silo. If you are a public charity under 501c3 or a 501c4 organization, to which 4958, I mentioned before, the intermediate sanctions, excess benefit rules, if those apply to you, again, those get to that issue of is an individual who is an insider receiving some benefit that is not commensurate with what that individual has provided to the organization. Typically that comes up in the compensation context, but it's not that limited at all. So again, don't take those as viewing them in a silo. Make sure that those are somehow interacted or involved in your conflicts process, so that you can ensure that not only have your directors and officers met with their duty of loyalty, but you have also complied with federal tax law. We've actually gone so far as to incorporate those concepts into our conflict of interest policy, so that we have a different form for a private foundation versus a public charity versus some other type of 501c organization. And we're not doing that because it's legally required. That doesn't have to be in your conflict of interest policy by any means. But we've done it to make sure that our clients don't forget, to make sure that it's front of their mind. And when they address a conflict issue and pull out that policy, which I hope they are doing, they remember that there's another piece that needs to be considered kind of hand in hand with it. And of course, I think all of this goes without saying, again, hopefully you do have those conflict of interest policies in place, but hopefully you also have procedures in place and processes in place to keep those policies front of mind and to monitor the potential conflicts that may arise within your board. That may take the place of an annual statement that your board signs with a little, form at the bottom that says, hey, who are you working with right now? It may be something, more heavy-handed than that. I work locally with a number of different nonprofits, 501c3s, that manage local public improvement districts. So they're getting tax money and making various improvements and providing various public-oriented services to a certain area, a certain neighborhood. As you would imagine, most of the folks on those boards are developers or in the real estate industry some way, somehow. Owners of buildings, owners of developers, renters, whatnot. So it's very rare that of all these improvements that these groups make, planting trees, fixing a sidewalk, hiring folks to keep the streets clean, down to taking positions on maybe zoning issues or going down to City Hall to talk about a new development or a new something that's going to take place in the area. All of those have a major potential to impact constantly with these with the personal interests of the folks on the board. And so in my mind, that should be like a, popcorn popping in the microwave. There should just be, disclosures left and right at those board meetings saying, oh, hey guys, just a reminder, you remember I'm on, I own half of that developer. We need to probably talk about this before we go forward. So just a quick real life example. I think I covered all of these already, really just the examples of the types of situations where duty of loyalty comes into play. Okay, and then our third, and what would typically be last, but we're covering 4 today, our third duty is the duty of obedience. This one I really hate talking about because on some level it seems so silly. On the other hand, there's probably a lot of folks that don't carry this out. Ultimately, this is the requirement that directors comply with applicable law and that it act within the parameters of the organization, primarily with respect to the mission or purposes of the organization, but in addition to that, in accordance with your organizational documents, your organization's rules and policies, your certificate or your articles, your bylaws. And I think this is where, I have a bit of a personal bugaboo. The number of clients that come into me, new clients that I haven't worked with before, and I as part of that initial intake process say, okay, well, bring in your organizational documents, let me see your bylaws, and they're like, oh, well, gosh, we don't even really know what those are. I mean, we kind of know what the rules are, but we just make it up as we go along. Or, I mean, we have those, but we don't really follow them, or we haven't updated them in 20 years. And I mean, a couple things have changed since then. I hear those sorts of things a lot. And the first place that my mind goes to is, well, if that's the case, if you don't know what applies to you, if you don't know what your organization's rules are, maybe you don't even know what your mission or your purposes are because it's not well defined, hasn't been updated in your organizational documents. How in the world are your directors and your officers supposed to be compliant with those items? They don't even know what they are. So I think that brings up a different issue, which is one of governance and compliance, but it ties in with this duty of obedience. And then, okay, and then here are just, again, some examples of duty of obedience and how this arises. And I've listed things here like, regulatory requirements and reporting requirements, familiarity with the documents and how the organization operates, and hopefully some form of periodic review of those. And I will take a moment to just remind you that, by no means is anyone expecting for every member of your board of directors to be able to spout off every tiny governance nuance that's in your documents. That's not the expectation here. No one is expecting your board or any member of them to be filing your Form 990 or preparing it or being so familiar with it that they can recognize an error on, part 12, line 2, column G. That's not what we're talking about. We're talking about that high level oversight to ensure that those things are happening and to ensure that they appear to be happening in a reasonable and compliant way. And then the last item that I'll focus in on here is this concept of prudent investing. In my mind, again, this is one of those fiduciaries that on one hand, I kind of want to roll my eyes at a bit because it's not that complicated. On the other hand, it's important. This is a duty that has typically been viewed as rolled into the duty of care. But in recent years, particularly, I think with the adoption of a MIFA and the focus on changing investment standards and prudent investment, I think that this has taken on a little bit more of a life of its own and is now being viewed as almost a fourth type of fiduciary duty. But the essence of it is not that different from the duty of care that we already talked about, in that it's the standard of what an ordinarily prudent person would do in a similar position, a like position, under similar circumstances. And so I think, if you apply that standard to each investment related decision based on your own state parameters and state law and regulatory framework, I think it usually becomes pretty clear how to move forward. The other thing that I'll take a moment to throw out for your attention or draw your attention to in this regard is, depending on the version of a MIFA, that Uniform Prudent Management of Institutional Funds Act that I mentioned earlier, depending on the version that your state has adopted, a MIFA addresses this prudent investor concept. It also, or at least some of the versions, have additional duties that apply either to an institution that's managing funds or sometimes to the individuals within the institution. So that would, again, be its own topic for an entire hour, and it's very state specific, and that not all of the states have adopted the same version with the same language. So just drawing that to your attention so that you can be aware that that is out there. And then that really wraps up most of my presentation, but I did include a few more excerpts in the PowerPoint, really just so that you can consult back to them later, around some of the best practices and kind of basic responsibilities. These are, again, not really legal concepts. These are more aspirational, strategic types of things that consultants would talk about. But I still think they're useful, and I think they're helpful in sort of jogging your mind when you're thinking about how does your organization, how does your board, how do your officers carry out these duties we've been talking about. Some of this might help you kind of flesh that out as to how it works for your organization and what the types of things are that you might want to consider. Same thing for this good board slide. I'm not sure that I would even come up with the same 10 items if you were asking me what a good board looks like, but that's not to say that these are not good considerations and things to consider and think about. Same for this good governance slide. These are all based in board source and their publications. So with that, I think we've got just a couple minutes left. I don't know if there are any questions that have been submitted, or Andy or Sam, any questions that y'all want to raise. I'm happy to spend a bit of time on that if it's useful.
My question for you, Danika, this is Andy again, is are we going to get in trouble because we didn't take minutes from this meeting? Just kidding.
Good, fair question. No, I think we're good. I think for this we are covered.
That is fantastic. Excellent. We really appreciate it. That was very informative, very interesting. I personally used to serve on a nonprofit board, and as you were talking, I was thinking, yeah, that's why I decided not to serve anymore, because I'm a person who travels a lot for my job, and I was missing so many meetings. I thought, I don't want to be held accountable for decisions that are made in my absence.
Yeah.
But,
no, I think that's entirely fair. It's interesting. I've shared this story, and I think it could carry some judgment with it, but I'm going to share it anyways because I think it's along the same vein. I was on the board of a local organization. That's something that I was pretty passionate about. And when I had my second child, I planned to take 6 months off. I was not going to be working legally or otherwise. And I ended up resigning from that board because I just thought, if I know I'm not going to attend a meeting for 6 months, half of a year, how in the world? How could I possibly exercise any of my fiduciary duties or even have any claim to do so? Not to mention the disservice I'd be doing to the organization by taking a spot that a more active, engaged board member could fill. So yeah, I think it's an important thing, and quite honestly, something that a lot of sophisticated professionals don't always think about because they're really more focused on the commitment they've made to the organization. They're not always thinking about personal impact in the way that they need to be, hence that board education piece we talked about. So no, I think that was very smart of you, Andy.
Well, I have another question that comes from my personal life.
Sure.
25 or more years ago, I was part of a small nonprofit that was, for all intents and purposes, it operated a lot like a startup, entrepreneurial, independent, for-profit business. It was founded by a visionary person who had this great idea. And she created a board in order to meet legal requirements that friends and other people she knew from the industry. And frankly, I think probably this is how a lot of nonprofits start, where the founder really is the person with the vision, and they put a board together. And then we grew them, and there was this awkward moment in the history of this organization where the board started to realize some of the things you're talking about today, and thought, well, I was sort of just on the board to help out my friend who had this idea, but at this point we have to start sort of getting serious and being a real board. So I guess there's that transition from being founder-led to being more buttoned up. I don't know. Do you run into that kind of thing in your
Yeah,
practice?
there absolutely can be. And I think, you know, as you said, there are organizations that start out that way. There are organizations that start that way, but that's really never how their board acts at all. And then there are others, particularly where the founder is kind of the donor or a primary donor, where you really see it very heavy-handed. And yes, I think some of those organizations head off in a less than favorable direction and start down that road of kind of founders syndrome and whatnot, where, you know, we start running into a lot of trouble. But for those that have, you know, good board members who are paying attention and understand, at least on some level, understand these concepts, yes, there does come a point, and in fact, I've been working with an organization to exactly that regard of, you know, we have our founder, she put everything together, she funded a whole lot of it. It was her passion, her idea, you know, you could go on. But luckily, in this scenario, she recognizes that she can't keep all of her tentacles in everything forever. And she recognizes that for the long-term longevity and success of this organization, she needs to back off and help the board, who are all of her friends, who she asked to join and support this organization and has shared her vision with. She needs to help them and give them an opportunity to kind of draw that line between her as founder and donor and her as executive director and their duties and responsibilities as board members. But unfortunately, you know, I've seen a longer list of situations where that didn't happen. And it sometimes can become a bit uncomfortable. Sometimes it's very useful to have a lawyer involved in those instances so that we can kind of play bad guy and offer up some insight. But yeah, you see it go all sorts of different directions, and that is a very common issue that nonprofits, particularly ones that are in their early stages of life, run into.
Interesting. Well, I don't see any other questions. I do see one person has hit the hand raise button. And if you did that because you were trying to get our attention so you could ask a question, it would probably be best if you would go to the questions tab and type your question in. I'll give you a moment to give that a try.
Someone's asking
okay.
if we can get a copy of the PowerPoint.
Yes, we will submit that to all of a recording of this as well as the PowerPoint. We'll submit to everyone on the call today.
And I do see something on here. When we were having those audio issues in the beginning, I think where I dropped off was at some point where I was mentioning charitable trust. I saw something, a question about that. I was just going to allay anyone's concerns. I didn't say a whole lot about charitable trust. Really, all that I said was it's a form of entity. You see them more in the endowment and the private foundation context. And if you have one, you need to be aware, because the way that fiduciary duties and obligations apply to your board members and your officers may be significantly different. So that was all I said, if that was your question.
Okay. I'm glad you clarified that. Thank you. Sorry for everyone for the audio issues we had today, but in spite of that, this has been a great, very informative session. As a former board member myself, I really appreciate it. And we really appreciate everyone's time today. Thank you again. You can see Danika's contact information there. And of course, if there's anything regarding JMT Consulting, if you want to learn more about us, you can go to jmtconsulting.com. Hopefully, many of you on the call today are already our clients, but anyone out there wants to ever talk about nonprofit systems, that's what we're here for. Thank you so much, and have a great rest of your day.
Thank you, everyone. Thanks for having me.
Take care.